whole truth, and nothing but the truth. So help me God. Thank you.
Thank you, Mr. Babe. Will you be speaking in English? Are you happy with that? Or?
English is fine.
Is fine? Yeah. Thank you. For the record, could you state your full names, address, and your profession?
My name is Dennis Jeffrey Babe. I'm a land surveyor by profession, and I'm currently the Principal Secretary in the Ministry of Lands and Housing for the Department of Lands, and I reside at Buffalo.
Thank you. And can you confirm that you are currently the Principal Secretary at the Ministry of Lands?
I confirm, yes.
Yes. And how long have you served in the Lands Department or in the capacity as Principal Secretary?
I've served in the capacity as Principal Secretary since 2018 in the Ministry.
And could you just briefly explain to the Commission what records the Ministry holds in relation to land in Seychelles, and what sort of types of documents, what information they contain, and how far back they go?
The Ministry the Lands Department is primarily mandated to oversee the management of state land and to also conduct all land transactions on behalf of the states. So all the records that we have captures all transactions that government has done over the years since we start keeping records. And we also administer and manages lease on behalf of the state to land that we lease out. In addition, the department also is not just mandated to oversee the management of state land, but to also exercise specific technical functions, which include the surveying of properties and the regulation of surveys, and also the GIS section, which is a branch which deal with geospatial data.
Thank you. And what is your experience in relating to cadastral surveying, land registration, and land administration?
I'm a licensed surveyor by profession, which means I'm well conversant with respective laws that has to do with land registration. And in regards to land management, I've been in the ministry since as the principal was 2018, so I have the wealth of experience.
Sure. And we were informed yesterday by the registration division that the land that the Cccl quarry and the magazine were situated, or still the Cccl are situated, is under a leasehold.
It is correct. Yeah.
And could you give us the background? When was the lease originally entered into?
Initially the property was government purchased the property from the Hazelbear.
Sorry, can we just confirm that that is S5500?
S5500, yes.
Sure. So, yeah. Sorry to interrupt you. You were saying yes?
Yeah. And the first lease that we entered with Cccl was dated in the year 2001. That was for a 10-year period, November 2001. The terms of the lease was for a 10-year period. But then Cccl came back to government saying that given the size of investment that they are willing to make to make the quarry active and profitable, then they will need to reinvest. So that necessitates an extension of the lease. So we drafted a new lease of 30 years in 2006 for 30 years. That's in July 2006 for 30 years, yes. With under the same terms and conditions as per the previous lease.
And that is 13th July 2006?
Correct, yes.
For 30 years, so up to 2036.
36.
Right? And when you say the same terms, what were the terms of the lease?
The terms of the lease was in terms of the rent to be collected annually, was pegged at 600,000 rupees per year. And then there was the terms and conditions for quarrying and paying the annual rent on the lease, along with rent review periods, which was every 5 years at the date of the first signature of the lease, and other conditions such as what are to be kept on the grounds and what, for example, if CCL is extending the quarry to an additional part of the property, what are the procedures that they should engage with to go through before they can actually start removing the overburden and doing the quarrying of the property.
Thank you. You started at 2001, that was the first lease, but CCL occupied that property from way before.
Correct,
so,
yes.
Could you perhaps give us the background?
I will not be 100% au fait with the technicalities, but from what I've been able to grasp is that at some point there was a special project unit that was renting part of the property from the initial owner for quarrying, and eventually government entered into a negotiation to buy the property for a full-scale quarry. It transpired that the actual transactions to purchase went through in 1998, following a couple of back and forth between the owners and government, which involved some court proceedings, and government actually became the owners of the property post-1998. I would expect that at some point SPV transformed from SPV to CCL at some stage. Yeah.
And so who were these original owners?
The Heirs Robert. That's Gérard Philippe Robert.
Do you have the documentation in relation to that?
I have documentations of the proceedings of the court, but I can make available to the commission so I can retrieve the necessary court documents.
And just very briefly, those proceedings awarded the property to the state?
Correct, yes.
Is that correct?
Yeah.
And that was in 98, you said?
1998, yes.
Okay. And we heard yesterday that 1998 was the same time government was deciding to privatize some of the parastatal companies. Yes, CCL had been transformed from a SPU to a limited liability company in 91.
Mm.
And so it ran as CCL from 91 up to 98, at which point the government decided to sell CCL to private owners. And that was said yesterday. So that ties in with what you're saying. You will provide us with the court proceedings that you say you have. So before we go, I wanted to ask you whether, and I think we can discuss that at a later stage. Perhaps let's finish on the lease. You said they held it as leasehold, and that it commenced 2001 and is still subsisting up to 2036. And we have copies. They were produced yesterday from the registration division. We have the certificate of the original search, and we also have the lease agreement. Those are the two documents that were available to us. We were also told that CCL have 5 other properties. I think those are held as freehold. Do you have those on you?
No, I don't have those on me.
Okay.
I don't think it's rated.
Sure.
Yeah.
So you're not aware, but we were given official searches of those 5 other properties. And we were also told yesterday that they have restriction notices placed on all the properties. Are you aware of that?
No.
No, you're not. Okay. And so are you able to tell us from the lease agreement what are the dimensions and the total area of the premises? under that lease?
The lease is for parcel S 5500. The total square meter is 500,335.34 meters squared.
Okay, I was trying to work that out in acres.
That will be 50 acres. 50 hectares, sorry.
50 hectares, right?
Yeah.
So it's fairly quite a large parcel of land, right? And you told us that the annual rental on that lease shows 600,000 per year.
Per year, yes.
We noticed on the official search it's increased now to 900.
Correct. That's primarily due to the rent review clause. So that's every 5 years. The rent shall be increased between 50 to 25%, subject to valuations that are conducted by the ministry.
And, sure. How is that rental determined? Is it fixed by the lease or subject to periodic market valuation reviews?
Subject to period market valuations.
And it's to change every 5 years according to the lease, you said?
Correct, yes.
And do you know whether CCCL have been paying that rental regularly?
Prior to 2023, yes, they were paying. We kept a very close eye on because that's on the revenue projection on our side.
And from 2023 to date?
I'm not too sure of the last statement of accounts, but I can verify.
You have to verify that, okay. And does the lease impose any conditions on CCCL, particularly in relation to storage of explosives or hazardous materials?
Clause 14 of the lease, I believe, makes specific mention to that, whereby, if I can just quote directly from the lease. Not cause or permit. No, that's clause under subclause. Subclause 8, section 15. Not keep any explosive or hazardous materials or goods on the demised premise without a written permission from the Republic.
That's 11, clause 11, subclause 14.
Correct, yes.
And so you said that provision restricts the keeping of explosives and hazardous materials on the premises without the permission of the state.
Correct.
Correct. And according to your records, has the Republic of Seychelles authorized CCCL to keep explosives or hazardous materials on the premises?
Not what is reflected on file. So my answer will be no.
So according to the records that you possess, CCCL does not possess permission or does not have permission from the state to keep explosives on the premises?
Correct.
And
yes.
they did not have as at the time of the explosion in 2023?
Not that I'm aware of.
Thank you. Thank you. Let's talk about the distances of the... did you ever go to the premises?
No.
No, you don't. So you're not aware of where the explosive magazine, it's called a magazine, we're told, was located?
Subsequent to the explosion, the GIS section was tasked to assist in the mapping of the affected residents so that we can actually formulate a clear plan in terms of what has been affected and the radius, including where the magazines were kept. So we have data in terms of where the magazines were being kept, based
Sure.
on the intervention that we did after.
So are you able to tell us exactly the location of the magazine? Because we are aware that the regulations require the company to submit a location plan and a construction plan detailing exactly the safety distances from the neighboring
Yeah.
properties. Do you know whether that plan was submitted prior to the explosion? Or does the ministry have any records?
Probably not with the Lens Department. Maybe they've submitted something with the Planning Authority.
Sure.
Yeah.
We've asked the police, and we're not aware of the police having it, because there was a requirement also to give the Commissioner of Police. We will be asking the Planning Department. But with the Ministry of Lands, you certainly
we
don't have.
yeah.
So tell us about the document the work you did, that you said you did.
After the incident, actually, the GIS section assisted the authorities to actually map out the location of where the magazines were based on the impact, and also to assist with the mapping out of all the properties that were affected, so that we have documented the evidence to try and see what was the effect, and for government to decide now what will be the mitigation measures to actually assist with the reparations and everything else. So that's the whole why we got into the works that we did, but purely from the mapping perspective.
Sure, and that was after the
Correct,
explosion, huh? Prior to that, you had never done
No.
this exercise.
No.
And from what you did, were you able to gauge the distances? Like, for instance, what distance, what was the closest neighboring properties to where the explosion was?
Based on what we've did, which is basically a desktop analysis based on the information that we've gathered, we've been able to establish that from the where the magazine was being stored, closest distance to residential was 177 meters closest.
177 meters?
177, yeah. And to the residential, to the light industrial area, IEA, the closest one was just behind the bus stop along the road. That's 101 meters, so that 101.
So 177 was to the closest resident, and
Yes.
101 meters was to where?
The closest industrial property, which is just across the road.
And the reason we ask this, because the regulations provide mandatory minimum distances for, hospitals, schools, homes, government buildings, shops, etc., ranging from, I think it's 26 meters for every 50 kg of explosives. So, for instance, explosives of 5,000 kilos, explosives had to be, the closest distance would be 360, somewhere around there, 360 meters away. And we know, for instance, that at almost any one time that Cccl imported explosives were in the region of 40,000 kilos, which meant that it had to be quite a far distance. So the information you've given us is very useful. Could you tell us what was the distance from the airport?
I don't have a distance from the airport, but as a comparable, the distance from that to the church, which is one of the closest building to the airport, is about 1.9 kilometers away.
1.9 from one of these buildings?
Yeah. So that will put the airport closely about 2.5 kilometers away. But we can establish that, surely.
Sure.
Yeah.
Please, would you? Are you also able to tell us the flight path of of the aircrafts in terms of where the location of CCCL premises are, in terms of where the explosives are?
Yeah, we can work it out based on the information that we have. Yes.
You can work that out. So if you don't mind providing that information to us. And does the ministry have any records of when CCCL first established the explosives magazine on their property?
No, we don't.
No, you have no records of that. We were told yesterday that at the time of the sale from the government to the new owners, there were no explosives kept on the property. So we know as at 99, when the new owners took over, there were no explosives being kept on that property. So any development would have happened, we assume, after that. We're still trying to establish, and perhaps CCCL or planning would be able to give us the precise dates of when those magazines were established on the site.
Okay. Because
it's quite significant in terms of, especially knowing when the other construction, the new construction came about around it. Because the Explosives Act is quite explicit in terms of even the powers of the Chief Inspector of Explosives having the power to cancel, for instance, the license to operate the magazine if new buildings come up around it, very close, in close proximity. So we appreciate the fact that you will give us those details. And could you confirm, you told us that the dimensions, have there been any changes to these dimensions since it was first established to December 2023?
No.
There was no
Unless
reason.
there is any new developments under construction, but
there was nothing, and there's no inconsistencies or gaps in the cadastral record relating to the CCCL site, right? And you have told us you've done that report, which you will provide to us, which shows the relationship of the site to the surrounding areas, right? The residential dwelling and commercial and industrial buildings, correct? Does it show that?
It shows that, but the data sets, it's just trying to think of the correct terminology, because it's a data set that we produce for SIA
yes.
and the planning authority, so I think they should be the one to present it to, in case you have further questions.
Yes, we will be calling planning and SIA to the meeting. It's just that sometimes the person that produces the document is the one that has to bring it in and probably explain, because they may not be able to explain it like you are,
understood.
Since you generated it. So obviously, anyway, from 98 or 99, when the new owners took over, and we're assuming the magazine would have been constructed any time around after 99, the surrounding areas of Providence have developed substantially, correct?
Correct, yes.
From the original, because that is 8 years ago?
Yeah.
Okay. Are you familiar with any of the regulations in the Explosives Act?
Not really. I had a brief read through last night, but that's as far as my knowledge.
That's as far as it's fine. It's not within your area, right? I'll jump all the. And are you aware if the ministry ever monitored the sites, the CCCL sites? Did they ever visit it? Or?
I'm not aware. Based on records on file, it would not seem that we've done any physical visits on site in a fairly long time, based on human resource issues.
Okay. But does the ministry ever monitor compliance of their lease agreements with the...
Yes, we do. Because as far as management of the lease is concerned, you also have to ensure that the compliance based on the permitted use and also the development that's been undertaken. Prior to 2022, that was not something that we were putting attention on. The focus was more on the collection of the revenues and to ensure that development happens. After development, there was no monitoring in terms of the compliance.
Sure. Yeah. So the fact that this provision you read out to me, which prohibits CCCL from keeping explosives on the property, was this breach ever identified by the ministry?
No.
I assume after the fact, after the explosion?
Correct, yes.
Okay. And did the ministry ever receive any complaint or inquiry from any person or authority about the CCCL's tenure or conditions of its occupation of the property?
I wouldn't say in a formal capacity because there has been ongoing complaints about vibrations and everything else by the close residentials for a number of years. That's one. And then secondly, there were sediments and everything else in the river, which the ministry was trying to resolve in partnership with the Ministry of Environment. So those were the nature of the complaints that reached the ministry, be it verbally or perhaps sometimes through emails, but not in relation to other aspects.
And nothing formally on record?
Not that I know of.
Okay. And did you take up those issues with CCCL?
I don't know, I'm not too sure.
You're not sure of that,
Yeah.
It's fine. And are you aware of any charges or mortgages or anything? Well, we talked about the restrictions, but charges or mortgages on the property?
I'm not aware what I would expect that there would be if there is an element of investment which they will need collateral, which the lease provides for, to raise capital for investing.
Okay, I have some more questions, but perhaps I'll ask Mr. Ruku if he has any. Nothing? Dora, do you have some questions? Yeah.
Mr. Babe, you've stated that government purchased S5500 from Hayes Wobe.
Correct, yes.
Did they purchase or did they acquire it?
Going through the records, it would seem that there was an agreement from government with the Hayes to purchase, and then at some point the agreement was being executed, and then at some point there was a rethinking by the Hayes.
I beg your pardon?
There was a rethinking in terms of the way forward, and then so government had to go to court to actually now finalize the transaction because the transfer was never signed. So that's why the government took the matter to court to get a transfer.
Why was the transfer not signed?
I'm not too sure. Maybe for the Hayes, there might have been some dispute amongst themselves or things like that, yeah. So I think the matter before the court was just for the specific performance, given that there was a contract per se.
Are you aware whether there were any plans for the property to be transferred back to the original owners?
I am aware that along with the TRNUC, the government launched an initiative to return properties that they acquired in a period of time. So there was an engagement with the previous owners, which are the Hayes Wobe, to return the property. But we haven't gone as far as to execute the transaction to return them back, along with what the policy framework stipulates.
What year?
That initiated was initiated in 2021, and the transaction has been ongoing since.
Was CCCL involved in that initiative, or was
As
the
a
representative made aware that there was
yes,
this initiative?
yeah, I stand corrected, but we met with them once to further explain the policy initiative by government, and I think we wrote to them. I can confirm that. I will need to confirm this, whether we actually state our intention in writing.
Okay. Now, that initiative to potentially transfer S5500 back to the original owners, on what basis would you have been able to execute that, given that government had a clean legal title to it? What would have prompted that decision?
Basically, the gist of the policy for the return of land acquired through a specific period was with the aim of actually resolving some of the issues based on how government acquired the property and became into possession of the property. If the owners felt that the process by government at least undertook to obtain the property either by duress or some sort of putting pressure on the owners, and then the policy, the initiative that was launched was the intention to allow the previous landowner to put a claim forward and to substantiate their claim by evidence, and the government will look at it within the framework of the policy. If they qualify, then the process to actually now to start the process to return the property based on other considerations.
Okay. You've stated that based on duress or the conditions under which government acquired the land. But this one, I think you've stated there was an agreement to purchase.
Correct.
So it was a transaction between the parties, government and the previous owners.
Correct, yes.
I would presume of their own free will and volition. So where would duress have come in under
That's
that case?
also things that the ministry has to establish in terms of when we are treating the claim, to try and see whether it fits within the parameters. As I recall, with other cases that was before TRNUC, those were made by the heirs after being the children. So probably in their account, they might, when they're putting their claim forward, they might feel that government actually strong-armed them into a deal. But we don't. That's something that we have to unpack as and when we're dealing with the claim before we pronounce ourselves whether we're going to return it and what are the conditions that we will return it to the previous owners. So they still have to satisfy those conditions.
Okay. So the initiative that you said the government was considering, or it was about to transfer the land back?
Government was considering.
Considering.
Yes.
And your ministry was consulted?
Yes. The process has been led by our ministry once the policy framework is in place.
Now, regarding CCCL, were they privy to the dialogue?
We did two things. We sat with them. We explained the policy to them as a lessee, because they are part of an agreement with government. So as a lessor, we approached them. We told them this is what government intends to do. There has been a claim that has been brought forward. We're looking at it so that we can have a feel of what is it that they are thinking. And I think also we send a formal communication to them in writing, but I can confirm that later on.
So you informed them of what government intended to do? To do? Do you mean it was going to consider the claim, or it had already made up its mind that
no,
it was
it has
going
not
to
really
return?
made its mind. Once we received the claim, the fact that any decision that the government would take would have an impact on them positively or negatively. We see it as our duty to at least consult with them for them to be made aware that there's a claim that has been lodged and government is treating it. At the point of actually having reached a decision, then we'll have to communicate with them in a formal capacity to tell them that, listen, government will no longer be the predecessor, somebody else will be taking a set of government. We haven't reached that stage yet, but it was just initial consultation for them to be made aware.
Now, in situations like this where people are still feeling aggrieved about acquisition or disposal of their property, in this case to government, do you go back in time to look at the consideration that was given? Because I assume there was some kind of consideration.
Yes, correct.
That was paid to whoever transferred the land to government of Seychelles at that time. Now, in the event that it was, in the case of a compulsory acquisition, there still would have been some form of compensation, right?
Correct, yes.
Now, did you go back to verify what transactions took place, whether there was any form of compensation or properties given in that particular case?
For all those cases, we have to go back. We have to establish how government became the owner of the property, what was the procedure, so that we satisfy ourselves that the claimant coming forward has a valid case in line with the policy framework that government put in place at that time. So we did go back, yes, to establish the consideration and the manner in which government acquired the property in the first place.
Okay. And it is a possibility that at the time the claim was brought by the heirs, that they would not be aware of all the facts.
It is a possibility depending on how...
that existed when the transferor transferred the
Yeah.
land to
Yeah.
government as transferee. Okay. Regarding the lease of S5500, was there a variation of the lease on 21st of May 2018?
Yes.
Okay.
That was to reflect the rent, annual rent, which is revised every 5 years.
From the deposition of one of the witnesses yesterday, we found out that Cccl had a freehold title to S5276 and S1702. Was it government properties that was transferred or from private entities?
Can you just repeat the parcel number, please?
S5276 and S1702. The first one was purchased in 2001, second one was purchased in 2006.
I cannot confirm this. I will need to verify if I make any statement. Yeah.
But from your knowledge of perhaps GIS, would that be in the vicinity of the quarry or somewhere in
I can tell you if
Cascade?
it just it's 5276, huh?
Yes.
Yep. That will be within the lagoon side going towards Buya of the Cccl compound, just opposite.
So it would adjoin?
It's not part of the quarry. Probably my guess would be they might have bought it from a private individual that was frustrated by dust and everything else, by the activities.
I'll just refer to the lease. The term imposed on Cccl not to keep explosives without the written approval of the Republic. Was there anyone from your ministry monitoring observance of? No, there was none. Okay. And you stated that you became aware that this provision was being breached after the explosion?
After the explosion, yes.
Mm-hmm. Whose duty was it to issue the written approval? Was it your ministries or some other entity?
It depends. The way that we would approach it is we would also consult with the police or whoever, based on the Explosive Act, has the mandate to to provide licenses. If they have the licenses, then we'll give permission.
Okay.
Yeah.
Now, did CCCL ever request that you issue such approval in accordance with?
Not what I've seen on record. Yeah.
And if they did, would that be in writing or?
In
would
writing.
that be
Normally,
verbal?
all requests for, yeah.
Okay, thank you. That is all from me.
Thank you.
Yes, could you just give us a brief description of the history of the land use and the development of the Providence Industrial Estate? Like, for instance, what land use was applicable to the Providence area at the relevant times in 2023? Is it mixed use, industrial?
I would rather the planning authority that is mandated that provides that information, yes.
And so your department does not know, would not deal with that issue of land use?
We don't deal with the issue of land classification, but once that land has been classified, we just operate within the classification matrix that is provided by land use planning.
Sure. So what applied to the surrounding areas of Petit Paris and Cascade as at 2023?
That would take consideration which other factors, what's there, and other things by the urban planners to put the classification there. It's part of the ongoing process that they do for land use, for industrial estates, for land use for districts and everything else. So planning might be best to give you a very detailed account of.
Sure.
Yeah.
Thank you. Let's talk about the damage, the assessment of the damage, rather, to the surrounding areas. Did the ministry identify each parcel of land that sustained damage as a result of the explosion?
I think we did, yes.
You did?
Yeah.
And you're able to provide a report of every parcel by reference number, and the registered owner, of course, of all those areas or properties that were damaged?
Yes, we can, provided that the information collected, which was authenticated by CIA based on the visits, are correct, and we can share that information, no problem.
And do you know whether there was an estimated value of the extent of the damages?
I think there was, yes.
There was, and that report can be availed to us, right?
From Seychelles Infrastructure Agency, yes.
CIA, right. How many residential properties in the Petit Paris, Cascade and Providence area were identified by government as having been damaged?
I don't have the figure on the top of my head.
You don't have off the top of your head now?
No.
We heard it was in the region of over 400, somewhere
Not too
around there.
sure.
You're not sure?
Yeah.
And commercial properties, they
That
were also identified as damaged, right?
Yeah.
You don't have the figures?
That also,
now?
I don't have the figures.
Okay.
Yeah.
And so it was not your ministry that would have commissioned the report on the extent of the damages. It's CIA? Planning. Which ministry would we
It would be CIA and planning,
together?
under perhaps the stewardship of DRMD, which had the mandate for disaster and everything else.
Okay. And maybe just in closing to ask, are you aware of whether your ministry or any other ministries ever commissioned a report or a study or an assessment of just the risks associated with keeping explosives in close proximity, whether it's CCCL or UCPS?
I'm not too sure about CCL, but I think UCPS undertakes a study of such on their premises, along with the urban planners and also, to some extent, Ministry of Environment. But for that specific site, I'm not aware.
You're not aware?
No.
Okay. And in your assessment, were there any failures within the ministry or coordination between the ministries or government authorities that contributed to a situation where the magazine was permitted to remain in close proximity to residential and commercial development?
Not in my... The only thing on our side was just for the compliance component. That's the only thing I can comment on.
Yeah,
Yes.
sure. And is there any other matters within your knowledge that you consider relevant to the commissions that we should know about?
not necessarily, no.
Sure, thank you. We will require all the documentation that you say you have available, and if you don't mind availing those to us as soon as possible.
Correct, I will.
If there's no other questions, we thank you for your time, Mr. Barbie. You're free to leave.
Thank you.
Thank you so much.
Welcome.
This is the end of the session for the morning. Our next witness will be at 13 hours. That's 1 p.m. Correct? Thank you.